I am appearing in behalf of petitioner. My lord, kindly keep it in Passover, short Passover.
Lord, I am for the petitioner.
Other side, because there is a problem with the list. So if the other side is not there, I'll not take up.
My Lord, twice I have served notice of the.
That's not the problem. We have seen there is a wrong endorsement in the list.
Then, my Lord,
Not today, next Thursday.
Next Thursday.
কল করে যান তারপরে স্পেশালি অ্যাসাইন্ড করুন ধরে যেটা লেখা আছে সেটা নিতে হবে কিছু করার নেই
I'm for the petition. My lord, last occasion, your lordship.
all parties are
First,
there only
please
then
to-
I'll take up otherwise I won't
Take it, take it.
next
Lord.
চলুন কল করুন 373 তে কেউ নেই 374 কল করুন তাহলে লোকে আসবে
For the petitioner.
If somebody was mentioning for the
Mr. Sen is appearing for the.
respondent somebody was just now mentioning as to why it
Let
is
me
not
start.
appeared.
Or should I pass over? Oh, he is coming.
He's coming very good বাজে কাজ এম্বারেসিং আমার লাগছে এবার থেকে প্রত্যেকদিন আমাকে এটাও চেক করতে হবে অর্ডারের সময় লিস্ট ঠিক হয়েছে কিনা
On the last occasion, my Lord, you lost directed to serve the learned lawyer of the state.
yes
Does
the
intimated.
problem is today because of the endorsement again they will not appear it's difficult for everything to be checked by the court it's very difficult you check the endorsement in the list then you check the serial number
Then may appear, but there is, I don't know.
somebody was just now online
Yes. Somebody called my junior also. That whether he will do this case or not. He's coming. But the problem is not state.
Mr. Dhar was appearing
Mr. Dhar.
Suprating Dhar somebody ask him to call বারের নোটিশ দিয়েছেন কোথায় কোথায় নোটিশটা কোথায় পাবলিশ কোথায় হয়েছে আচ্ছা আমাকে তো কপি দেবেন কোথায় আছে সেটা you proceed Mr. Tiwari let us see or better I'll pass it over let them come passing it over to take this notice in the meantime if Mr. Dhar can also come
Yes. Please make.
এটা পাস ওভার করে আলাদা করে রাখুন Can't be helped. Chalo. দিদি যে লিস্ট যিনি তৈরি করেছেন ওনাকে নিয়ে আসবেন সন্ধ্যাবেলায়। স্পেশালি অ্যাসাইন লেখা আছে, স্পেশালি অ্যাসাইন কল করুন, কিন্তু লিখে ফেলেছেন উল্টো পাল্টা, এখন তো কিছু করার নেই, যা লেখা আছে সেটাই কল করুন।
373 is 73 হয়ে গেল 373 500 বার আছে।
চলুন চলুন।
The petitioner.
Bring your other side. Passing it over. Chalo.
And the previous day also the state was not there.
Can't be helped today because of this difficulty in the list. If you bring your other side, only then I'll take. Don't press
Yes.
unnecessarily.
Yes, sir.
Yes.
To have for the petitioner, whether your lordship is taken or not.
If both sides are there, I'll take up.
My lord, then kindly take it not. Tomorrow it will be taken, my lord.
Let us see if the listing is proper. I cannot promise anything now. I mean, I'm absolutely embarrassed. It's unfortunate.
That's fine, my lord. Let it up.
If I'm on the petition, I'm not.
The other side, bring it.
Then may I tell you not today, my lord?
In respect of 373, I have informed my other side. He is coming.
If he's there, we'll take up.
Yes.
Small indulgence, 404. Both sides are not present, but can it be kept next week?
Ask somebody to be here tomorrow. I'll make it next.
Lordship, kindly 360.
Please don't mention now. Let the list be called up.
What
চলুন,
happened?
call করুন, আপনি দাঁড়িয়ে যাবেন না। Unauthorized to call করুন এবার। Unauthorized occupancy যদি both sides থাকে তাহলে হয়ে যাবে। এমন আজকে করে দিয়েছেন যে আমি কিছু কাজই করতে পারবো। তাতে আপনার সুবিধা হলো, আমার কিছু হলো না। আনফরচুনেট।
Lordship, 368, kindly make it not today, Lordship. 368.
Not today.
My lord, Mr. Chakravarti is not there. He is presenting the status.
Is
He is for the opposite side, my lord.
not today.
Bhattacharya is on the opposite side.
Not today.
Then let it be on Monday, Tuesday or Wednesday, my lord. Thursday, kindly keep it off. my lord.
Thursdays, it's not usually taken up, which is because of the mistake that has been committed
No,
in the printing of the
no.
list. Thursdays are for unauthorized occupants
So
matters.
let this matter, since it is a tax matter, let it go on any Monday, any Tuesday, any Wednesday, my lord.
In any case, it will be Monday, Tuesday, or Wednesday if I make not today, because tomorrow we take specially assigned matters. Tomorrow also it won't be called. Not today.
The answering respondent is the center.
Nobody is there. It's unfortunate. Such an embarrassment for the court.
Your lordship.
And this is not happening for the first time. Every time something of this kind happens.
My lord, the advocate for the petitioner is on the legs.
Not today. Mr. Chatterjee, your other side has come? No.
Not yet. I have told his
Mr.
clerk.
Tiwari's other side has also not come.
He
But
will-
that gentleman mentioned online and he has disappeared thereafter.
He mentioned the matter whether your lordship will be taken. I am standing outside.
I have informed his clerk. His clerk was with me, you believe. He told me matter has been called on. Let me see what is going on there. I understand nobody is there.
যা করেছেন আজকে কোনো কাজই আমি করতে পারবো না।
Matter was actually fixed today, sir. Bhaskar Bhattacharya is actually here. Bhaskar Banerjee is here. I'll try to.
My lord, for 23, I would seek a short passover. Yes.
Other side is not there.
But in this 24, Malad, there was certain instruction to be taken, Malad. But day before yesterday, Mr. Tanna Bhatta said, "Ki Dada, I'll take a short adjournment as because those instruction has not been received by him." Malad, Monday, Malad. Malad, grateful lordship.
Yes, he has come. His brief is coming.
My lord, the brief has arrived.
373.
Milord, as per Milord's direction, Milord, I have used a supplementary affidavit. Milord, copy of it, sir.
Copy has been served only yesterday evening. I have gone through, it is 2 pages. There is nothing much. I have gone through this. Now, my lord, your lordship kindly have a glance to your lordship's last order, where I have specifically indicated that the notice has not been served.
Order written. Narrow error. Opposition to the last matter की could be. तो असुविधा हो. Opposition reply. Yes, my lord. My lord.
Yes.
My lord, it was sent to both of it. One, my lord, the receipt has got lost. We have stated it. The other to the one to the site, the other to the his residential address.
Lost.
That receipt.
No, my lord, no such apartment is there. Lost.
My lord,
This,
yes.
the record specifically says, your lordship, can you see the order of the estate officer?
My lord.
No, 1 minute, 1 minute.
Yes,
let me controvert this thing.
Yes, yes.
Order of the estate officer.
My lord, kindly come.
My lord, this is the
affidavit in opposition.
No, opposition on the page 20. This is the notice under section 4.1, 10.9.
Yes. Both the address has been written.
10.9. My lord, 10.9/2021, page 20 of the affidavit in opposition.
Both address has been written.
Very well. Page 20. My lord, this is notice under section 4.1 and 4.2 on 10/9/2021. Very well. Now you will also kindly come to page 22. The order after this notice. You will also kindly see. The matter is taken up for hearing today. It is seen from the records that the show cause notice dated 10/9/2021 under section 4 and subsection 3 of section 7 by this forum was sent to OP through speed post at the recorded address of the OP, and the same has returned back with remark insufficient address. Now your lordship kindly see this supplementary affidavit. Page 4 and page 4, then page 5. Page 4, what is the address? Chetla Yard, Chetla Station Yard. No specification of the block number, plot number, nothing. And also the residential address, nothing is there. Then you will also kindly see page 5, insufficient address. That has been recorded. Where is the state apartment in the order that has been lost?
Milord,
Why he has said all these things
Milord, we have
beyond the
stated it.
record?
Milord, kindly, Milord, we have stated it that it was signed in both the address. The notice was, Milord, if your lordship kindly comes to page 20, it has been addressed to both the address. It was sent to both the address and has been stated on oath that it has been sent to both the address. One did not come back. The other came back unserved. So it was served by the process server. That has been annexed.
Now,
The
now,
process server
now, my lord,
has been annexed.
process server is also I am showing. Process server is also I am
Yes,
showing. What is the process servers? Yes.
my lord. The question is, I have stated that, my lord, paragraph 5. Paragraph 5. Of my supplementary affidavit. Milord, however, in view of observation and detection passed by Milord, the central dispatch caused search of the record and has found certain document, but other documents could not be traced out. From the record, it could be found out that such notices were sent to Chitra address, scrapped back with the insufficient address, as would be evident from the endorsement made on the return envelope, a copy of which is annexed here to and mapped with the with letter R1. As the letter come back and the same was served by process server of SMP, but door was front port. Accordingly, same was posted in the property. In regard, the process server is annexed here. Then paragraph 8, I say the other letter sent to the residential address has not returned, but inadvertently both the receipts are not traceable. So, my lord, the thing is two things. Firstly, my lord, the notice has been addressed to both the address. My lord, we could not trace out that sleep is very small thing. We could not trace out. But the thing is that we are stating it on oath and we are annexing the process server reports. My lord, if a process server reports is also one of the good way of services. And accordingly, that service has been done properly. And thereafter, the court has recorded that, my lord, that has been annexed with the supplementary affidavit, R12. R12, page 6 and 7, my lord.
Which door?
Door close means obviously if it is sent to
Which address?
my lord, the next page will suffice.
Nothing.
Next place will suffice.
Nothing.
That letter was sent to Chetla address. And my lord, recording is that the door was closed and it was pasted. I, page 7. I, Sri Ranjan Kumar Sarkar, designated process server as affixed a copy of the notice under section 4 and or section 7 under section 5 and 7 summons of on the property under schedule. And a notice on 14/9, 1355 in the presence of the witnesses also there. Thereafter, my lord, the advertisement was caused. The advertisement was published that has been annexed with my affidavit in opposition. And accordingly, my lord, they did not appear, choose not to appear, and this has been appeared. This is the one of the aspects. Second thing, my lord, they have now got the knowledge of this. My lord, a read court, my lord, knows better than me that interference is in read court is generally when something is done to be shown to be arbitrary, or my lord, there is no appellate forum to this. Here, section 9 provides for a specific appeal. Why they are bifurcating this? That is Shottavati, starting from Shottavati Tanna 2000 AIR 2010, it continues to 2024. That when there is a alternative forum, ordinarily the writ court should not interfere. If not, nothing arbitrary is so. I have shown that we have tried. The notice was sent. Court has recorded. The forum has recorded. Why, as quasi-judicial forum, record something false? And we have provided this in the supplementary affidavit, the process server's report. So when we failed, the advertisement was caused. And my lord, the answer, my lord, the query that was raised by my lord on the last occasion is that you have to first start with the serving in an ordinary process. If it fails, only the question of advertisement comes. We have shown that we have done it through ordinary process. And when it fails, as per the direction of the learned state officer, you have caused publication of the notice. Now they have got an alternative remedy under section 9 going before the appellate forum, that is the district judge, Alipur. What prevented them? Process in a regular process, all the orders were there, chronological orders were there. It could not be taken into possession. Then police welfare is there, and by police welfare have taken possession. They have their alternative remedy. And this is a really, whether a service has been done or not done is a really a disputed question of facts. We have seen it, face apparent, something has been done. Now these disputed questions of fact need something more than these court's apparent perusal of the records, which the appellate court can do.
Now, my lord, here it is shown that it has not been sent to the proper address. First, page 4. Your lordship, kindly see page 20 of my writ petition. No. Page 20 of my writ petition, your lordship, kindly see. They are later. They are later. Yes. Dear sir, the letter written to me without prejudice by the land manager, executive manager for estate, engineer estate, outstanding dues against your occupation under plate number D4592. This is the plot number. This is absolutely vague. Chetla station yard. It is a huge, vast area. It cannot be identified. Which is the plot, which is the thing, which is the... By name, this cannot be identified. So address must be specific. Then it can be said it has been proper service. I have refused it. My lord, if I say, your lordship, kindly see, I stay in Dhakuria. If anybody written Aurobindo Chatterjee Dhakuria, can the postal receipt, postal peon found out me? Because I am not the minister or I am not anything else. Even I am not a honorable judge or the executive judge. I am nobody. So unless address is given to my residence, nobody can find out where it is to be sent. So it is 459-2. This is the particular plot. If your lordship has my learned pen, can show any document that they have served 459-2. No. Which they have served, this 23A Vijay Bose Road, I have received it. Starting from caveat, I have received it. I did not deny that I have not received. My door was closed. Nobody is there. Nothing. So, and your lordship, kindly see, this is also, there are some fishy things. This is something they have said that the residential address they have sent, they have lost. If it is lost, then burden of proof lies on them. Onus lies on them, then the court will take into consideration there is no service at all. This is a consistent view of our High Court as well as the Honorable Supreme Court. There is no question of disputed question of fact. Then your lordship, kindly come to page 6. My lord, your lordship, in your lordship, while your lordship in the bar, your lordship has seen many process servers report while appearing in for the civil division matters or civil appeal matters. My lord, can it be taken into consideration in process servers report where he has gone? May I put this question to myself? The time he has indicated 13:55 p.m. This Gopal Boiraggo, who is Gopal Boiraggo? Where he stays? Is he nearby? A person from the street come and ask him to
My lord, my lord, it speaks of that a notice is to be served by the state officer, because no obligation for the owner to serve it. It is under the state of action that when an application is filed, it is being then section 4 and also section. My lord, my lord, my lord. My lord.
No such.
You know,
O-
no. There
Only,
is.
only thing has been prescribed in the rule, format of the notice. Nothing else. ওটা rule নয় ভাই, ওটা act.
Sir, আমি বলছি
বলো।
একটাও দেখছি, just section 4 I am referring to first section 4 and then I'll come to the rule. The section 4 fix of my lord, I have only one.
No, no, আমি দিচ্ছি। Your lordship can take mine.
If the state officer has information that the information is received by the from the application as an information that any person is in unauthorized occupation of any public premises, that he should be evicted, the capital side issue in the manner hereinafter provided a no sheet is writing within 7 working days from the receipt of the information regarding the unauthorized occupation, calling upon the person concerned to show why an order of eviction should not be made. Rule,
Rule 4.2, is your lordship can you see? The notice shall specify the grounds on which the order of eviction is proposed to be made. Require all persons concerned, that is to say all persons who are near or occupation claim interest in public.
Yes, my lord,
Rules.
manner, my lord, of
Rules.
service of notices and orders. A notice, yes, shall by delivering or tendering a copy of the notice or other as directed me to the person for whom it is intended, or to any adult person of your family, or by sending it by registered post with acknowledgement in written address to that person at his usual last known address of the business. Where the copy of the under subsection delivered or tendered signature in respect of subsection 1, section 4.5, or where the person of an adult or sign or where such cannot be just my lord. Sub-rule 3. The notice of I was reading this. Shall be affixed on the outer door or some other conspicuous place of ordinary. Miller, that. Yes. Cannot be found. Miller, door close me. Milord, the question is this first. Milord, question is the first one was sent by post. It is not by us. Yes, my lord. I sent it by post, Mr. By Mr. X. I cannot cite that as a proof of good service. My lord, question is there is also a question after using all due diligence, all due and reasonable diligence. My lord, may the appropriate frames. That could not be found. Milord, it was sent. Milord, the question, Milord will find out that in a notice under section 4 and 7, both of it, uses two address. Though it was sent.
Only one.
Other Milord, that could not be found out. We have stated. No, the receipt, both of them could not be found out. We have stated one came back. No, Milord will kindly, that is not the case. Question is, yes, Milord will, Milord, the supplementary affidavit first. Opposition has not got this, Milord. Milord. Page 10. Milord. Page 6. Okay. Milord, yes, Milord, one is for Pradeep and other is for Pankaj Chakraborty. Yes, Milord. Yes, Milord. Milord, records, Milord, I cannot create records. Milord, question is, Milord, will kind out rule 4 speaks of that if we try, we fail. What is my understanding? If we try, we fail. Milord, due diligence, these two services, both Milord, this one and that one, Pankaj and Pradeep, we tried it diligently. Milord, then Milord. Milord, on oath we have stated it was sent to that address, but the record, it was not. And Milord will find out, Milord, that.
My lord, I have given your lordship yesterday.
Milord.
My lord, may I give one offer to my learned friend? Let him talk with his client. I have already categorically submitted before your lordship on the last occasion. Whatever dues they have, let them inform to us. We have already given 5,50,000. Leaving aside that, we will pay in installment.
My client to be present here. That Milord.
No. Let him submit next Thursday. Let him submit the document. What is the dues? I will talk and beforehand let him give it to me. Only the only thing. Yes. No. Only for rent. Rent. Only for rent. Your lordship can see all orders are only for rent.
Milord, the orders speak unauthorized occupation is also there. Question of unauthorized occupation.
No.
Milord, let me come back on next, sir. Let me come back.
Your lordship kindly see 1 minute. Your lordship kindly see. My learned friend says unauthorized. No, it is not. The order says, yes, page 30 of the affidavit in opposition. Page 30 of the affidavit in opposition, my learned friend. 30, last paragraph. In my considered view, a sum of rupees 7,50,000, 56,000, 30, 30.
The opposition.
414.24 of the plot number such and such for period 1792 to 3422. Both days inclusive is due and recovered from OP. Only thing. And your lordship, he has calculated that along with the interest. already on the basis of page 20, they have given us 9,58,000. Your lordship, kindly see page 20 again. 1 minute. Yes, 9,58,270. Out of that, we have paid 5,50,000. Thereafter, this possession has been taken, which is totally illegal according to me. That will be decided by your lordship. But out of this, we have already paid 4 lakh and odd is due. What is the due and payable till date? I am not saying 24 or 23 or 22, whatever it may be, till date, till 4th of December 2025. What is the due? Let him give a detailed chart, leaving aside this 5,50,000 without calculating interest and penalty. That is to be negotiated by my client and his client. That is not to be decided by the court, at least so far I understand. No, so far I understand that I also cannot go. Yes. Now, my lord, I have already given him the offer that this is the only issue. You take the amount, we will give you, we will pray for certain installment.
Let me come back. This is something which is coming, my lord, today. Let me
No,
come back.
last week I have
I'll take instruction.
last week also
No,
I
my
have
lord,
said.
that week it was really, my lord, focused on the service. This, my lord, let my lord come back on next week. I'll tell my client to come and have a discussion.
this malad, the DM has malad send a notice. Now malad after filing of the writ application malad, after 1.5 month malad, for the hearing malad, since the order was appealable order. Malad, but malad, no malad, but before the other day malad, when I have mentioned the matter, that time malad, they have not sent any notice malad. But malad, in the meantime malad.
IPF for the Murshidabad Jilla Parishad Mahilas. But I was on my legs, my lord, before court number 15. But I was, well, junior. I have to call the other side, my lord. I called. Extremely sorry, my lord. Extremely sorry for the inconvenience. I'll. And there was no allegation, my lord. I never meant it, my lord. I'm extremely sorry for it. I never meant it, your lordship. I'm extremely sorry. I just said that it was to appear on Thursday, my lord. Somehow it is not there in there. It's my bad, your lordship. I tender my apology, my lords. I'm extremely sorry. That was not my intent, my lord. Anyhow, I'm sorry, your lordship.
Should I start? You. Huh? What do you do?
Let's start with that.
No, my lord, this is a case. Now, this is a case, my lord, on 9th of July 2004, an agreement for lease was entered into. It is basically for 21 years. In the lease deed, my lord, there is a clause for termination. There is a clause for, my lord, appointment of arbitrator. Now, by invoking, my lord, termination clause, the Murshidabad Jilla Parishad, my lord, terminated my Mr. Dhar Junior is there. Now, by invoking the termination clause, my lord, the respondent Jilla Parishad, my lord, terminated the lease deed. Now, my lord, even after the termination, my lord, I continued to pay rent, and they have been accepting the rent, my lord, from me. Thereafter, my lord, I moved the civil code. Civil code, my lord, my prayer was that the lease which was executed on 9th of July 2004 is still subsisting, and the Jilla Parishad should be restrained from giving the property to third party. Now, my lord, in the civil code, my lord, initially passed an order of injunction. Initial order of injunction was the 10th of July 2024. Injunction order was continuing. In the meantime, my lord, what they have done, they have filed an application under Section 8 of the, my lord, Arbitration and Conciliation Act. Now, my lord, civil code ultimately, my lord, here both the injunction application and Section 8 application. Yes. Now, my lord, I will make, my lord, my best point first. My best point is this, my lord. There is an agreement. Agreement, my lord, entered by myself and the Murshidabad Jilla Parishad. They have invoked, my lord, by clause 26 of the agreement. They have invoked clause 26 and terminated my lease deed. Now, my lord, when I approached the civil court, they said arbitration clause is there. My lord, arbitration clause, by showing the arbitration clause, my civil suit gone. Initially, I own the matter before the London Trial Court. Ultimately, High Court held, no, Section 8 is there, so arbitration clause is there, so go to the arbitrator. Now, High Court will not refer the entire dispute to the arbitrator. Now, I file an application under Section 11. That is pending. Monday, 9th is the date fixed for final hearing of Section 11 application. Section 9, Section 11 application. Now, in the meantime, also file a Section 9 application. In the Section 9 application, civil court passed an order of injunction. Now, my first condition would be before your lordship, after Vidyatoliya and all these judgments, whether, my lord, this West Bengal Public Land Eviction of Unauthorized Occupant Act, whether they can invoke it, number one. Well, what they are doing, they are basically, my lord, in my responsible submission, my lord, It is. It is in the. Yes. No, well, there are certain things has to be considered. No, well, this act was enacted in the year 1962. And this act, Milord, preamble says, Milord, it is for the purpose of Milord, eviction of unauthorized occupant. Now, but there are mechanism has been provided in the act itself. Now, Milord, question is to be decided, Milord, whether as on date, a person, Milord, is having the protection of a civil code can be considered as an unauthorized occupant. Number one. Second point, Milord, the person. Unauthorized occupant or not, that has to be, yes, concerned authority has to be decided. There is no doubt about that. Concerned authority has to decide that. Now, well, here in this case, we are considering the background of this case. Now, we will kindly consider two things. Today, Milord, today I'll be giving answer, Milord. So far as this 1962 Act is and 1996 Act is concerned, Milord, I will make submissions. The 62 Acts, Milord, 96 Acts, Milord, overrides the 62 Act. I will make submissions to that effect. 1996, Milord, Arbitration and Conciliation Act, and subsequently after the various judgment of the Supreme Court, even if Vidya Dolia and subsequent judgments, and on the same points also, when Milord, the authority is proceeding, Milord, by invoking the special statute. Milord, special statute normally, if it is for the benefit of tenant, then Milord, it can be carved out. But here, Milord, I am the tenant. They are claiming the landlord. What they have done? There was an agreement. Arbitration clause is there. They invoke the arbitration clause. The matter has been referred to the arbitrator. Naming of arbitrator is now just mere formalities. Now, in such circumstances, what they are doing, they are invoking 1962 Act for the purpose of evicting me. They are also invoking Milord Bengal Public Demand Recovery Act 1913 for the purpose of realization of money. Now, will kindly consider the fact in this factual background, I will be on the street. Despite having arbitration agreement, despite moving the civil court, despite having order of injunction from the civil court, despite moving the high court under section 11, all at part their peril. Now, they have resorted these state acts for the purpose of ousting me. Now, ultimately, where I will go? I am asking the question to myself. I have no place to go. Well, they will be resorting 1962 Act, they will be out me. They have already invoked Bengal Public Demand Recovery Act 1913, claiming 3 crores and something else. Now, who will decide my arbitration petition? My arbitration petition subject matter, kindly consider one thing. The subject matter of the dispute. Section 9 and Section 9 speaks about. No, it is pending. Section 11 application pending. 9th is the next date, 9th of December. They are also saying the same thing. The 1962 Act will override the 1996 Act. The point is, now kindly consider one thing. Today, Lord, a person who is moving this formal court, I have approached. I already sent a notice under section 21. They did not give any reply. I filed an application under section 11. Now, what the basic point is this: they are trying to avoid this mechanism. They are trying to adopt their mechanism, and by their mechanism, they are trying to take the benefits of state machineries and oust me. This is a plain, simple logic. Nothing more, nothing less. Plain. May just place certain things, then I will come. But kindly have a look, Milord. Just I will be very short, Milord. I will be making my best point first. Thereafter, I will be going. Milord, kindly take, Milord, this agreement, page 36. Yes. Now, page 36 is the deed of agreement, Milord. It is dated, Milord, 9th of July 2004. Now, Milord, your Lordship, Milord, kindly turn, Milord, page 41. Page 41, 41. Yes. Page 41, your Lordship would find that agreement speaks about there shall be a core committee of the following, comprising of the following members to advise on the policy guidelines, and role shall be on advisory capacity. Now, Milord, first your Lordship would find A, that is Sawadipati Murshidabad Jila Parishad. B is the Milord district magistrate as a member. Now, Milord, kindly turn, Milord, page 44. Page 44, Milord, clause 26. Has you also got it? It says, Lord, in case of lessee's default in payment of rent for 4 months, then in that event, the lessor shall have a liberty to take over the possession of the said building, including all equipments installed therein, and the tenancy shall be deemed to be terminated. There is a clause 26. Now, my lord, clause 27 speaks about, my lord, renewal. Clause 27 says, subject to the fulfill of the terms and conditions of this presence, the lessee will have the option to extend the lease of the said center, including the land and building and structure erected thereon, including the plant machineries and medical equipments, furniture, fixtures, for a period of 21 years on expiry of the lease hereby granted, and provided the lessee gives a notice to that effect in writing to the lessor of his intentions to do so at least 3 calendar months before the termination of the present lease, and if the lease is extended for another period of 21 years at the same rate of rent, that will be settled afresh after discussions. Now, clause 28 speaks about, my lord, this upon in case of dispute and differences arising between the parties herein, or regarding the validity or interpretation of the agreement, the matter shall be referred to the arbitrator of the sole arbitration of a sole arbitrator to the district magistrate Murshidabad. So, my lord, district magistrate Murshidabad is the sole arbitrator. My lord, district magistrate Murshidabad, actually Murshidabad Jila Parishad, my lord, is being controlled by the district magistrate Murshidabad. There is no doubt about that. Well, I have shown to your lordship, my lord, that page 41. Now, my lord, your lordship, my lord, kindly turn the next, my lord, page 57. Yes. Page 57, my lord. It is, my lord, termination of agreement dated 9 July 2004. Now, my lord, your lordship would find what they are saying. This is to the agreement dated 9 July 2004 and subsequent supplementary agreement dated March 3, 2005, executed between the Murshidabad Jila Parishad and Asia Healthcare Development Private Limited, wherein the Rabindranath Tagore Diagnostic Medical Center has been let out such and such all 21 years. The said agreement inter alia provided. Now, second paragraph, you will also can have a look. Second paragraph, as per records, you failed and neglected to pay the rental under the said agreement for the 4 consecutive months starting from October 2021. Thus, Jila Parishad do hereby invoke clause 26 of the agreement dated 9 July and hereby forthwith terminate the tenancy in respect of Rabindranath Tagore Diagnostic Medical Center and hereby requested such and such. So, they have invoked clause 26. Clause 26 of the lease deed for the purpose of terminating my lease agreement. Now, after this termination, my lord, they continue to take, my lord, rent. It is going on. Subsequently, when they put the property on auction for the purpose of settling in favor of third party, I approach the civil court. Civil court passed an order. I am not placing that. Kindly takes, my lord, page 72, the order of the High Court. The stand of the Jila Parishad, my lord, would be evident from this order. Now, I just place certain pages of this. Paragraph 1 says, my lord, these 2 appeals have been preferred against the same order in FMT number such and such for the grant of injunction in favor of the plaintiff, respondent number 1 has been assailed. Whereas in FMA number 816 of 2025, the rejection of an application under section 8 of the Arbitration and Conciliation Act 1996 filed by the respondent number 1 appellant has been challenged under section 37 of the Act. Now, my lord, it says, my lord, the main premise on which the application under section was refused by the land trial court, the different number 1, 2 was not the signatory of the agreement. As such, the parameter of section 8 are not satisfied. Now, my lord, kindly skip all these things. Now, my lord, kindly turn paragraph 10, page 76. It says, my lord, learned senior counsel for the appellant side such and such 2017 5 SCC 185, wherein the Supreme Court inter alia held the plaintiffs herein were admittedly parties to the arbitration agreement, and it did not lie on their mouth to contend that since one of the defendants whom they had impleaded was not a party to the arbitration agreement, no difference can be made to the arbitrator. In the facts of this case, it was held that merely because one of the defendants was not a party to the arbitration agreement, the dispute between the parties, which essentially related to the benefit arising out of the retirement deed and partnership deed, could not be said to have been amenable to the reference to the arbitration. Now, my lord, next another side, judgment was referred. Now, my lord, kindly turn my lord, page, my lord, page 82. Yes. Now, my lord, honorable division bench will not discuss about the, my lord, group theory concept. The division bench says the group theory concept is not applicable, but however, it was said that section 8(1) of the 1996 Act has now incorporated, after 2015, the amendment to the said Act, not only party to the arbitration agreement, but also any persons claiming through or under him as an applicant. By necessary implication, the scope has been broadened to bring within the purview of the arbitration not only to the parties, but also the people claiming through them. Now, my lord, next, my lord, if your lordship kindly turn page 83, paragraph 27. It says, my lord, we must take note of the fact that the legislature in its wisdom deliberately used the expression a matter which is the subject matter of the arbitration agreement in subsection 1 of section 8, instead of restricting the subject matter only to the parties to the arbitration agreement. Thus, legal position as it stands as that is that if the dispute raised in a suit covered by an arbitration and a party to it or anybody claiming through it seeks a reference, as in the present case, the court is bound to refer the matter to the arbitration. Now, my lord, lastly, my lord, if your lordship, my lord, kindly takes, my lord, page 85. Yes. It says, my lord, paragraph 31, paragraph 32. The accordingly FMA number 816 such and such are allowed, thereby setting aside the order number 14 dated March 21, 2025, passed by the Civil Judge Senior Division First Court at Barampur, Murshidabad, in title suit number 6 of 2024 as a whole, and referring the dispute raised in the said suit to arbitration. So, my lord, this order was passed on 15th of July 2025. On 16th of July, this notice was issued by the subdivisional magistrate. Now, my lord, your lordship would get, my lord, at page 100, the notice. Page 100. My lord, may I just place, my lord, what the subdivisional magistrate is writing, my lord, may I just place it. It is, my lord, August 22, 2025, the order. It says, my lord, the additional executive magistrate Murshidabad Jila Parishad has informed the district magistrate Murshidabad Bhaid Memo number such and such, dated 16th of July 2025, that such and such, located on such and such, had been leased out by the Murshidabad Jila Parishad in favor of Asia Healthcare Development Private Limited, Charaji International Center, 12th floor, such and such. By the said lease was terminated by memo number dated such and 11th of January 2022, with a direction to give vacant and peaceful possession of the said nursing home within a period of 15 days from the date of this letter. Next, the additional executive Murshidabad has placed a proposal before the district magistrate Murshidabad to take necessary action for eviction of the unauthorized occupant of Mrs. Asia Healthcare Development Private Limited from the premises of Rabindranath Tagore Diagnostic Medical Center by invoking the relevant section of the West Bengal Public Land Eviction of Unauthorized Occupant Act 1962. The matter is duly been forwarded by the district magistrate Murshidabad to me for drawing necessary action. So, Lord, he is acting on dictation. There is no doubt about that. Now, he is not applying his independent mind. Next, hence, in my considered view, the illegal encroachment are required to be removed. The Lord, judgment was passed before hearing. illegal encroachment is required to be removed and evicted from the said public land for restoration of the lawful possession of plot number such and such, district Murshidabad by immediate owner to the Murshidabad Jilla Parishad. Being satisfied to that effect, I, Subdivisional Magistrate, Baharampur Sador, Murshidabad, being the collector as per provision of 21B of the West Bengal Public Land Eviction of Unauthorized Occupant Act 1968, as amended up to date from time to time, in exercise the power vested in me under the provision of section 3(1) of the Act, do hereby treat the communication as mentioned in above the undersigned as information received. Now, my lord, he is going on and information received, claiming the possession on such encroachment to the public land as mentioned in above, issue notice to so cause as to why he or she shall not be treated as unauthorized occupant in relation to all these things. Now, my lord, my first submission would be, my lord, this notice is absolutely palpably bad. Number one, now, my lord, this notice was issued on dictation of the district magistrate. So, my lord, the SDM cannot issue such notice on dictation, my lord. Number one. Number two, my lord, here, my lord, SDM is, my lord, is being guided by an authority who is in fact an affiliate authority. Who is in fact an affiliate authority. And now, my lord, kindly takes, my lord, I have used, my lord, two supplementary affidavit. First one is affirmed on 4th of August 2025. Level just one page, my lord, I'll just show to your lordship, my lord. One page. If your lordship, my lord, kindly takes, my lord, read petition once. I'll be coming to the supplementary first, later on. Kindly take, my lord, read petition 1, page 45. Page 45, 45. Page 45, my lord, your lordship would find, my lord, schedule of the property. That is, my lord, Khotia number 1, plot number 960. Now, my lord, kindly takes, my lord, page 100. Page 100, my lord, first paragraph, fourth line. The notice is in respect of plot number 960 part and 915 part or Moja, Baharampur, jail number such and such. So, my lord, the notice as and the Miller leased it. The land is not telling. Land is not telling. But this is also one of my points. Now, my lord, if your lordship, my lord, kindly takes, my lord, supplementary affidavit. Now, my lord, kindly take the supplementary affidavit. That is 4th of August 2025. Now, in the supplementary affidavit, my lord, I have annexed the order at page 4 passed by the, my lord, commercial court at Asansol. Now, my lord, this or if your lordship sees the order is dated 28th of July 2025. It says, my lord, I'm just reading two lines, that this is an application under section 9 of the Arbitration and Conciliation Act 1996 has been filed through e-filing on 23rd of July 2025. So, my lord, ultimately on 28th, my lord, when I move the matter, if your lordship, my lord, kindly turn page 9 of the supplementary affidavit. Page 9. The civil code, my lord, while entertaining section 9 application, passed an order saying, accordingly, the parties are directed to maintain status quo regarding possession of the disputed property as described in paragraph number 1 till the next date of hearing. Interim order, next date is 15th. Interim order is going on. I have annexed the order. Next supplementary video. They have filed one application for vacating the interim order.
The order was passed on 28th of July, Since then, the bench was vacant. We have filed an application for variation on certain grounds and for vacating of the order.
That's
That
when
absence, the bench was not
15
available. Recently, the commercial judge has been appointed, and the next date is scheduled on 15th of
15th,
December.
15th is zero. Now, in the next supplementary affidavit, which I have annexed, my lord, if your lordship, my lord, kindly takes, my lord, that was affirmed on 19th of November 2025. Now, my lord, during the pendency of these proceedings, my lord, SDM proceeded with the matter. My lord, SDM, my lord, passed an order on, my lord, 13th of November 2025. Kindly takes, my lord, page 4 of the supplementary affidavit. Page 4, my lord, order dated 13th of November 2025. Kindly skip over, my lord, page 4. Most of it. Most of
We
it.
have been served with this.
Served. Yes, it's real. Please.
It was given on the last day.
No, last, but last. Now, we'll page 4 of the supplementary affidavit, you will also find the order dated 13th of November 2025. But I am just not placing page 4, the first page of the order. Kindly turn to the next page. That is page 5, paragraph 4. Paragraph 4. Yes. Now, we'll all, yes. Now, we'll next. Kindly have a look, my lord, that paragraph 4, I am not placing that Hasibul Islam matter, and subsequently, that apart, my lord, it starts. That apart, so far as order of status quo dated July 28, 2025, passed in arbitration, miscellaneous arbitration pending before the commercial court Asansol is concerned, the same is inter se party and as such does not affect the pending adjudication in terms of the proceeding come so cause notice dated July 20. Yes, now kindly consider one thing. Today, rightly, wrongly, civil court has passed an order of status quo as regards positions. I am asking the question to myself: can the SDM proceed with the matter until unless that order is vacated by the civil court? Whether quasi judicial authority can say the order was obtained by non-est, and not only that, kindly it says, my lord, more concerning that the said order was obtained unscrupulously without disclosing the pendency of the proceedings under the Act of 1962. This is nothing short of playing fraud upon the court. Now, who is saying? The SDM is saying regarding the order passed by the civil court, competent civil court. In this background, in my humble opinion, there appears to be no impediment for the concerned authority to proceed with the hearing and in terms of the proceeding comes so cause notice. District Magistrate thus instructed me to proceed with the West Bengal land public land eviction of unauthorized occupant act in compliance with the instruction of District Magistrate. The submission of the landed advocate his mind is made up. Well, what hearing he will give to me? He is acting purely on instruction of the District Magistrate. Now, my lord, so far as my lord, now, my lord, so far as my lord, the SDM is concerned, my lord, if your lordship, my lord, kindly takes my lord act once. The preamble of the act says, an act to provide for the speedy eviction of unauthorized occupants from public lands. Now, if your lordship, kindly takes, section 2(1)(b). Section 2 says, in this act, unless there is anything repugnant in the subject or context, the collector means the collector in the land acquisition collector, Calcutta. B says, elsewhere the chief officer in charge of the revenue administration of the district includes an additional district magistrate and subdivisional magistrate or any executive magistrate specially appointed by the state government to perform all or any of the functions of a collector under this act. So, the SDM is acting as an officer, appointed under section 2(1)(b) of the act. Now, if it is so, kindly takes, section 7. Section 7, says, an appeal from an order made under this act shall lie to the commissioner of the division where the order is made by the collector. And I am not covering that. Next, the collector, where an order is made by an officer specially appointed under subsection B of clause 1 of section 2. So here, that concerned officer was appointed under subsection subclause B of clause 1 of section 2. So if he is an officer within the meaning of lot 2(1)(b), then the collector is the appellate authority. The collector is a district magistrate. So entire proceeding is nothing but a farce. When collector is directing to proceed with the matter, and a collector is the appellate authority. So enter, your lordship, I can foresee what will happen in the proceeding itself. So appellate authority and the trial court and appeal court will not merge together. Now, so far as this stand of the Murshidabad Jila Parishad is concerned, your lordship knows, Murshidabad Jila Parishad is a state within the meaning of Article 12 of the Constitution. There is a term called approve and reprove it. Murshidabad, it is the Murshidabad Jila Parishad harping from the very beginning that suit is not maintainable as because arbitration clause is there, and they file an application under section 8. Ultimately, the suit has been referred to the arbitrator. Now they are saying, they are contending that no, so far as this part is concerned, I am not on that. This is a special statute, so it will be covered by the special statute. Now, kindly have a look. I'll just cite one judgment regarding approve it and reprove it. This is an unreported, this is Sanjit Singh Salwan. Sanjit Singh Salwan and others versus Sardar Inderjit Singh Salwan. That is SLP Civil 29398. Soft copy. Now, your lordship, kindly, I will be referring just few paragraphs. Kindly state text first, paragraph 2. The issue that arises for consideration in this proceeding is whether the plea of estoppel in law can be permitted to be raised by a party ignoring its conduct that resulted in other party altering its position to its detriment in view of such conduct. Now, kindly consider this. I was fighting for that suit is maintainable and all these things. He was fighting for arbitration. I moved the arbitration court. Now he is just altered his stand as saying that arbitration is not maintainable. In that case, then if the civil court is in season of the matter and civil court passed an order of injunction, then quasi-judicial authority has no power to proceed with the matter. Otherwise, there will be an anarchy. Kindly consider, even if civil court is in season of the matter, with an order of injunction protecting the parties to the concern, can quasi-judicial body proceed with the matter? And total, so far as civil proceedings, civil court is the mother of all proceedings.
Yes, yes.
8A. Ouster clause of this act. Yes.
Court is there. Section 8 ये होता है ना?
Section 8. It says no suit, prosecution or other legal proceedings shall lie against any person for anything which is in good faith done or intended to be done in
8A.
8A. No civil court shall have jurisdiction to decide or deal with any question which is or under this act required to be decided or dealt with under the provisions of this act. Now, so far as 8A is concerned, now we'll consider. Now, Arbitration Conciliation Act is there, 1996 Act. This act is not 1962 Act. This act is a state act. 1996 Act is a central act. Now, my lord, if there is any repugnant between the state and the central act, Article 254 will come into place. Article 254 says if there is a repugnant, land is blood concurrent list. Now, not only concurrent list, central act will prevail. If there is any confusion regarding the subject, state legislation and the central legislation, the central act will prevail. The normal Article 254 is clear. Now, kindly think about the situation. Today, now, he is proceeding with this act. Now, I am proceeding so far as Arbitration and Conciliation Act is concerned. Now, 1996 Act, the arbitration clause is there. Now, after Vidya Dhulia, all these judgments, eviction proceeding can also be decided by the arbitrator. Eviction proceeding after Vidya Dhulia, eviction, my learned friend can go to the arbitrator and evict me in the arbitration proceeding itself. Well, think it otherwise. Today, my lord, kindly consider, kindly consider me, my lord, excuse me for repeating. Today, my lord, as on date, what is my position? I have a claim. My claim is more than 20 crores. I have a claim in respect of property in question, which is the subject matter of arbitration. Section 9 speaks about the protection of the property, which is the subject matter of arbitration. If you also can see the Section 9 of the Arbitration and Conciliation Act, it says the protection of, yes, it has to be preserved. So my claim around 20 crores, as well as the property, where my medical instruments and all things are there. Now, my lord, what he is trying to do? He is resorting. Doctrine of occupied fields, my lord, the doctrine of occupied field has to be read, my lord, with the context of the other acts. My lord, Arbitration and Conciliation Act is a subsequent act. Not only that, my lord, kindly no, but this also special act. Arbitration Act is also a special act. This is a conflict between the two special act. Arbitration Act, Arbitration and Conciliation Act is not a general act. It's also a special act and a subsequent act, central legislation. So doctrine of occupied field, my lord, has to be looked into. Yes. Yes. In that context, my lord, your lordship also. Parties choose the forum. A private form of court, parties choose the forum. There is no doubt about that. Now, in the private, now if there is a conflict, public and private, or in otherwise, today, my lord, if the land, which is the subject matter of a occupied field, is also the subject matter of the private field, and a subsequent that is, and the act and private field, subject matter of private field, which is covered by a legislation, comes subsequently. Now, in my responsible submission, my lord, in that case, subsequent legislation will follow.
Yeah, yeah.
My lord, if your lordship, my lord, kindly takes this judgment, my lord, that is which I hand over Sanjit Singh Salwan. Paragraph. Paragraph 13. 1-3. Paragraph 13 says, my lord, after the initial round of litigation, when the appellant sought to rely upon the consent decree and file an application under Section 9 of the 1996 Act for seeking interim measures, the respondent took a completely opposite stand and raised a plea that the compromise deed in the form of award dated 30th of December 2022 was a nullity in view of Section 92 of the Code. They persisted with the stand, which it found favor in front of the commercial court and thereafter in appeal before the High Court. The question, therefore, to be considered is to whether the respondent could be permitted to take diametrically opposite stand from the one taken by them in the earlier stage of proceedings, initiated by them so as to leave the appellants without any remedy. Next, paragraph 14 says, "My lord, in our view, it would be impermissible for the respondent to take such opposite stand from the one which they had taken while while initiating the proceedings, having specifically pleaded that the suit filed by them was not hit by the provisions of Section 92 of the Code. It would not be now open for them to oppose the validity of the compromise deed dated 2nd January 2023 by raising such ground. The pleading of the respondents referred to herein above clearly indicate that the concerned stand had been taken in the initial round of litigation to present litigation. They had stated that no occasions of the present proceedings initiated by them were maintainable, and at the same time, you are required to be decided on merit. Now, my lord, if your lordship will not kindly text, my lord, next paragraph 15. This position is fortified by the decision of this court in Mumbai International Airport, Supra. It was held therein as under. Paragraph 44 was quoted. It says, my lord, in an action at law, a game of chess. It says, well, can a litigant change and choose its stance to the suit, its convenience, and prolong the civil litigation to such bifurcated pleas? The common law doctrine prohibiting the approbations and reprobations is a facet of the law of estoppel and well established in our jurisprudence also. The doctrine of election was discussed by the Lord Censors, then it was quoted, and thereafter, my lord, next paragraph 46. Justice Ashutosh Mukherjee's judgment was also quoted by the Supreme Court. Next, your lordship would find in that case, my lord, the question of approval and reprobate was categorically discussed, and paragraph 17, my lord, if your lordship will not kindly come, my lord, paragraph 17. It says, my lord, next paragraph, second paragraph, the contention through the contention though attractive cannot enable the respondents to surmount the equitable hurdle of estoppel. Having lulled the appellant in having the dispute resolved through the arbitration and thereafter seeking disposal of their appeal on the strength of the award, the respondents are definitely stopped from now setting it up its invalidity. The issue is more about the estoppel by conduct and election rather than estoppel in law. So my submission would be before your lordship, my lord, it is them who had initiated the proceeding on a section initiated the proceeding of arbitration by stating that look here, the arbitration clause is there, and on their plea, my lord, High Court referred the entire matter to the arbitration. Now, can they, my lord, take a diametric stand and say the look here, the arbitration clause does not apply as because it is a special statute. 1962 Act will apply, and it is a special statute, so Arbitration and Conciliation Act goes. My lord, this judgment also, my lord, the Honorable Supreme Court, my lord, set aside the order of the Commercial Court as well as my lord, High Court, and ultimately, my lord, restored the parties to their original stand, not on subsequent stand. (1919) SCC 2292. 2292. Now, my lord, here, my lord, This is in respect of, my lord, arbitration and, my lord, public premises eviction of unauthorized act. This is 2019 SCC online, 2019 SCC online, SC 2299. 2299. Your lordship, my lord, straightway comes to, my lord, paragraph 9. Paragraph 9. It says, the subsequent development after filing a suit and of OMP was issuance of notice dated 9/11/2005 by the DDA to the appellant under subsection 1 of clause B1 of subsection 2 of section 4 of the Public Premises Eviction of Unauthorized Occupant Act 1971, the post determination of the lease. This notice was replied by the appellant, and appellant also sought stay of the proceedings along with the reply, but request was declined on 13th January 2006. Paragraph 10 says the so-called notice dated 9/11/2005 and the continuance of the proceedings was assailed by the appellant by filing a writ petition number such and such, and the said petition was dismissed by the learned single judge on 3/4/2006, permitting the proceedings to go on under the Public Premises Eviction of Unauthorized Act 1971. Now, my lord, paragraph 13 says, in terms of the order dated 29/10/2007, this court, the proceedings before the estate officer were permitted to continue, but passing of the final order was restrained. Ultimately, leave was granted on 10/1/2011, and the interim order was also made absolute. Now, my lord, if your lordship, my lord, kindly turn last paragraph, that is paragraph 18. Paragraph 18 says, my lord, where of the view that once the matter is sub judice in the suit, an appellant is not an encroacher on the public land, and the allottee in pursuance of the allotment letters or lease deeds of the DDA, and the lease have not been expired by afflux of time, or the reasons for terminations is stated to be the breach of the lease prior to the issue of amalgamations, which is pending discussion in the suit. Any action under the Public Premises Eviction of Unauthorized Occupant 1971 would not be appropriate if the appellant fails in the endeavor as in the suit or in appeal arising therefrom, then only the occasions would be arise for the proceedings to be taken under the Public Premises Eviction of Authorized Act 1971. So, my lord, my submissions before your lordship would be, when the civil court is in session of the matter and civil court passed an order of injunction, then, my lord, this subdivisional magistrate should stay his hand till the disposal of the civil proceedings. At least till the disposal of section 9 and thereafter, my lord, section 11 applications. Otherwise, my lord, the entire thing will go. Otherwise, the entire thing will go. Otherwise, well, I will be absolutely remediless. I will be on street. Despite pursuing, my lord, my remedies before the appropriate forums, by invoking these provisions, my lord, I will be on the street. SC online SC 2983. 2983. But this is a judgment, lot. This is also more or less on same arbitration and this Public Premises Eviction of Unauthorized Act. This is 2024 SCC online Supreme Court 2983. 2983. It's paragraph 2 says, my lord, the question of law formulated in this appeal is whether the Public Premises 1971 overrides the Arbitration and Conciliation Act 1996. In the said question is answered negative. The only question that survives whether the High Court committed any error in appointing the arbitrator while exercising the jurisdiction under section 11 of the Arbitration and Conciliation Act 1996. Having examined in detail it is clear that the said questions does not arise in the facts and circumstances of the case. We are guided by the existence of arbitration clause and the decision of this court in the case of SBI General Insurance Company Limited versus Kiss Shipping, which is discussed in the scope of the referral court interference when the valid arbitration clause exists. Now, my lord, if your lordship, my lord, kindly turn, my lord. Paragraph 12. It says, my lord, the question of judgment and order passed by the High Court, referring the dispute to arbitration, the appellant filed the present appeal. Although the questions relating to whether the Public Premises Act will override the Arbitration Act has been raised and argued before the High Court, this court issued notice in special petition on the basis of the questions so formulated. We could have dismissed the special petition on this very ground, but the notice was issued on consideration is appropriate to hear the appellant on the questions and decide the case. We will first answer the issue relating to the applicability of the Public Premises Act. Next says, whether Public Premises Act 1971 overrides the Arbitration and Conciliation Act 1996. This submission has to fail. The reason is simple and straightforward. The dispute is raised in the Section 11 applications relate to the promise and reciprocal promise arising of the agreement dated 26/9/2012. The right of renewal as well as the legality and propriety of the enhanced demand arose during the subsistence of the agreement. It will be on the interpretation, construction, and obligations arising in the agreement that respondents' claims rest. On the other hand, the public premises authorizes the ejectment of the tenant in an unauthorized occupations of the public premises and for consequential directions. The original lease is of where the validly subsisted till such and such, and the dispute between the parties relating to the period commencing from 12/9/2012 to 11/9/2015, when the lease expired. The Public Premises Act would not even cast a shadow on this period. If in so far as disputes relating to the right of renewal is concerned, it depends on the terms of the agreement. The public premises neither bars nor overlaps with the scope and ambit of the proceedings which were initiated under the Arbitration and Conciliation Act. Whether High Court committed error in appointing the arbitrator while exercising the jurisdiction under Section 11, we have already extracted the relevant portions of the order passed by the High Court. The revisions of shortage of charges occurred during the subsistence of the agreement. Legality and propriety will depend on the terms of the agreement dated 26/9/2012. Similarly, the right of renewal will also based on construction of the agreement. These two disputes will undoubtedly rise for the agreement between the parties. Clause 16 was quoted, and after the recent decision of this court, SBI General Finance Limited, the remit of the referral court to consider the application under Section 11(6) is clear and unambiguous. We need to examine the existence of the arbitration agreement. The context clearly delineated such and such and such. Now, Miller, kindly see last paragraph. For these reasons, we have no hesitations to rejecting the petitions and further hold that appellant entitled to cost and arbitration proceedings were stayed due to the pendency of the appeal by an order such and such. While dismissing the appeal, we direct the arbitral tribunal to resume the proceedings and endeavor to deliver the award as expeditiously as possible. Now, Millard, in this case, Millard, your loss was fine. Millard, I also submitted a letter to the authority concerned for renewal of lease. Now, Millard, so far as the letter for renewal of lease is also, Millard, arbitrable. As held by the Supreme Court, Millard, there is a judgment to that effect. And this is also the subject matter of the arbitration. Now, Millard, if that all my disputes which I have raised regarding the property in question, regarding my claim, regarding my renewal, if all these claims are the subject matter of arbitration, if these proceedings is allowed to continue, then my entire proceedings, which is pending or which would be pending before the arbitrator, but nothing remains to be decided. The appointment of arbitrator will be absolutely a paperwork. Now, my lord, in this judgment, my lord, this is my lord 2022-17 SSC 81. Two thousand 22-17 SSC page 81. Here, my lord, the Supreme Court held, my lord, even in case of, even after the expiry of the lease period, if I ask for renewal of the arbitration lease, well, High Court rejected the Section 11 application saying that renewal is not the subject matter of the arbitration, so it is not arbitrable, so it cannot be referred to the arbitrator. Well, Supreme Court held that even in case of renewal, it is arbitrable and it has to be referred to the arbitrator. Only on this aspect, my lord, I just referred this judgment, my lord. It will, lords would get it, my lord, paragraph 18. That this point, Supreme Court said that the arbitration clause cannot be rendered etious by refusal of the respondent state to renew the lease. Paragraph 18, my lord, last just fifth line or sixth line. The one sentence, my lord, is there, but case is based on that. I'm just placing this. It says, my lord, the arbitration clause cannot be rendered etious by refusal of the respondent state to renew the lease. Yes, yes. Yes. No, that is not the bundle level, but I have asked for renewal. That is page 87. Page 87 of the writ petition. By letter dated, my lord, 20th of January 2025, Lord, I requested the additional executive officer, my lord, Mustafa Jalapuri sir, by invoking clause 27 of the lease deed and requested him to page 89, your lordship will get it, my lord. Phrase lease deed could be executed in respect of the property in question for a further period of 21 years on certain terms and conditions as may be mutually agreed by the parties. No, my lord, I just refer the Vidyadhulia, my lord, your lordship. But stateway, your lordship comes at page 73, paragraph 79. Paragraph 79 says, my lord, the landlord-tenant disputes covered under the Transfer of Property Act are arbitrable, as they are not action in them but pertains to the subordinate rights in personal arising for the right in them. Such reasons normally would not affect the third-party right or have erga omnes effect or require centralization adjudications. An award passed deciding the landlord-tenant disputes can be executed and enforced like a decree of the civil code. Landlord-tenant disputes do not relate to any unalienable and sovereign function of the state. The provisions of the Transfer of Property Act do not expressly or by necessary implications bar arbitration. The Transfer of Property Act, like other acts, has public purpose and has that is to regulate the landlord-tenant relationships, and the arbitrator would be bound by the provisions, including the provisions which ensure and protect the tenants. And ultimately, paragraph 80, my lord, Himangiri was, my lord, overruled by the Supreme Court. Himangiri, my lord, the conflicting judgment was there that it cannot be referred to the arbitrator. Supreme Court says, in view of above, we overrule the ratio laid down in Himangi Enterprise and hold the landlord-tenant disputes are arbitrable, as the Transfer of Property Act does not forbid or foreclose arbitrations. However, the landlord-tenant disputes covered under the government rent control legislations would not be arbitrable when the specific court or forum has been given exclusive jurisdiction to apply and decide the special right and obligations. Such rights and obligations only may be adjudicated and enforced by the specified court and forum, not through the arbitrators, not through arbitrations. Now, we'll have paragraph 154 onwards, paragraph 154(4) and other things, my lord. Now, it is the settled proposition of law, my lord, it can be referred to the arbitrator. Now, if you will also, my lord, kindly takes, my lord, paragraph 154. Page 121. Well, it says, my lord, same, I'm just replacing, my lord, same thing, my lord, that it is, I'm not wasting your lord. Now, my lord, I just now sum up my argument. First of all, my lord, this notice was issued by the subdivisional magistrate on dictation on the last occasion, my lord, I have referred the judgment. So, my lord, he has not applied his independent mind, so notice has to go. Number one. Second point, my lord, this subdivisional magistrate, my lord, is an officer within the meaning of section 2(1)(b) of the Act, and he had issued notice while exercising the power under section 2(1)(b) of the Act. So, in that case, the collector would be the appellate authority. So, once the collector would be the appellate authority, collector is the district magistrate. So, district magistrate cannot dictate the subdivisional magistrate. Next, my lord, so far as this notice is concerned, my lord, this notice is absolutely defective one. This notice, my lord, speaks about two plot number 960 and 96915, but least it contains the 960. Now, my fourth point would be, my lord, the civil court already passed an order of injunction. So, the subdivisional magistrate under any circumstances cannot pass, even if he may proceed with the matter, but cannot pass any order in gross violation of the civil court's order. Number fifth point, my lord, that respondent Jila Parishad being a state, my lord, act fairly. My lord, they cannot take, my lord, the contradictory stand. Initially, they have taken that the arbitration clause is there. Now they are reverting back, saying, no, a special act will prevail. And so far as, my lord, this subdivisional magistrate is concerned, my lord, subdivisional magistrate already formulated his opinion. Paragraph 3 of the notice, my lord, clearly speaks that encroachment are required to be removed by evicting this Asia Healthcare. So, my lord, any hearing would be nothing but, my lord, an IWAS, absolute IWAS. Next, my lord, my next submission would be before next point is, my lord, that they are trying to evict me. I am trying to protect my position. So this is arbitrable. There is no doubt. Next, my lord, they have their claim. I have also annexed, my lord. If your lordship, my lord, kindly takes, my lord, page 93 once. My lord, they are saying that they have initiated the recovery proceeding under the Bengal Public Demand Recovery Act. They are claiming that 3 crores and something is due and payable from me. I am saying the 20 crores is due and payable from you by me. So, my lord, the dispute is, my lord, 3 crores, 20 crores. Dispute is in respect of possession of the property in question. Now, my lord, in such situation, in my respectful submission, my lord, arbitration would be the best available option. Otherwise, my lord, they may proceed with this with the help of state act and state machineries, and I'll be on street. And so far as my arbitration is concerned, when I'll get nothing, my property will go. They will realize money, and I'll also lose my property as well as I'll not get anything. Yes, my medical center, my lord, there is a crux of the matter. Construction is there by all medical. I also made construction. Some construction, original construction was there. Thereafter, I developed it. I spent crores of rupees. Not only that, my lord, medical equipments are there. Page 8, my lord, I have stated that. Can you see page 8? I have given a chart how much I have invested. The petitioner also, well, they have not used any opposition to that effect. It is a fact, my lord. The medical center was running. The medical center was running. All district magistrate, chief medical officer of health. Now they have issued notice to the respective licensing authorities not to renew the license. Now it is not in operation as on date. But I was running the medical center. There is no doubt about that. And it is going on for since 2004. And I have invested a lot of money for that. Now they have taken steps to see my license is not being renewed. Accordingly, my lord, on the dictation of the district magistrate and others, my license has not been renewed. So, my lord, these are the investment made by me. Now, my lord, after making this investment, my lord, if everything goes, my lord, I will be on street with the help of this executive officer and my lord, this district magistrate. So, my lord, my submissions would be before your lordship, my lord, that my submission would be before your lordship, my lord. Your lordship, my lord, kindly quash these proceedings. Lord, this proceeding, Lord, initiated with a very purpose, with a motivated purpose, Lord, in order to bypass the Arbitration and Conciliation Act, and they are taking, Lord, this contradictory stand. So, considering all these things, and this notice was issued with a biased mind, and this notice was issued on dictation, I have pleaded to that effect. So, Lord, in my respectful submission, your lordship, Lord, kindly quash this notice. These are my submissions.
No. This is first day, my lord, we had challenged the maintainability of the proceeding, my lord. That is why the maintainability point came up and the matter started. Because it is a show cause notice stage, my lord. I cannot, I had raised that point, so I did not file any affidavit to that my lord. My lord, if you lord, on the pure question, because some factual aspect has come out now, I just want to clarify that on the lease deed itself, that will speak for itself. So if your lordship sees the lease deed, it was granted with fixtures and everything. Whatever further investment that I cannot comment, but not only nothing has been constructed, it was already a diagnostic center run by somebody else. Now he was running under this lease deed with all furniture. If your lordship I will not go into the details, but just kindly have a look at one clause of the lease deed, it will be clear, my lord. If your lordship takes page 36, where the lease starts. Yes. Kindly see, it starts there. 38, your lordship will see. Whereas there have been discussion, negotiation between the lessor and lessee to let out the said diagnostic cum medical center along with the land described in the schedule below, along with plant machinery installed in the center. Fittings, fixtures and other installations on monthly rental basis, and lessees have agreed to take on rent the said diagnostic cum medical center and to run the same. So we were already running the diagnostic center. It was not possible for us to do it ourselves. So, my lord, we had given it on a private party. It was there, thereafter they came. So this is the proceeding, and kindly see, my lord, paragraph 1, once it is for a term of 21 years. As of today, it has expired by a flux of time. On 9th of July, 2025. My lord, kindly see the termination notice. I am saying this only to say that, my lord, the owner is Murshidabad Jila Parishad. Incidentally, district magistrate is the chief executive officer of Murshidabad Jila Parishad. Incidentally, he is the administrative head of the district. But if that is so, kindly think in terms of a private property. Private property owner is myself. I have to write, my lord, under the act, this is a special act, the Jila Parishad has to give an information to the appropriate authority for the purpose of initiation of proceedings. Why I am saying this? Because of the argument of dictation. District magistrate is in a dual capacity here. He is the chief executive officer of the authority who is the owner of the property. He cannot, within the scope of the act, Murshidabad Jila Parishad cannot file a civil suit for eviction, which could have been filed by a private party as owner for termination of a lease. Murshidabad Jila Parishad knows that there is a special act available in case of government property. So for the purpose of taking benefit of the special act, what he has done as the chief executive officer. I'll come to that. I'll definitely address your lordship on that. The lease deed contains the arbitration clause. There is no doubt about it. Now, my lord, when this question of eviction arose, he has given first is a termination letter. Termination letter, there is no point in going into the merits. I have said that these are the breaches you have committed under the lease. Factual. I have a right under the lease to issue the termination, alleging these are the breach. Based on that, so this is the starting point of the action. Additional executive officer Murshidabad Jila Parishad has issued the termination letter for termination of the lease.
In this case, we have an arbitration. There could have been a lease without an arbitration.
Yes.
There could have been a situation where the lessor seeks to terminate the lease.
Yes.
On the ground of any breach having.
Yes. Yes.
If in such a situation, a termination letter had been issued, had the lessor not been entitled to.
Of course.
100%.
Only provision.
100%. There is no doubt. At the same time, the lessee is also entitled to approach the civil court also. Now, if
there I join an issue.
Now the question is section 8. Now, my lord, if I approach the civil court first and civil court pass an order of injunction, then whether, my lord, that special court or special whatever statute or whatever authority can proceed with the matter.
Well, I want to answer this first. This particular contention, whether if a civil court is approached first and some sort of an order is passed, can the authority thereafter initiate proceedings? It is a different matter that in this case, first the proceedings are issued. But since it is a proposition of law, I'll take that case. No, not the arbitration. Suit was first. But termination, then suit. Section. Yes, suit to arbitration, yes. But section 9 was thereafter. Section 9 was thereafter. Section 21 notice. Yes. Referral. Thereafter my notice. Yes. I'll just check the date of section 21 once, then we'll come back to your lordship. But this proposition is more important. Whether a civil court, first of all, can grant an injunction restraining a proceedings to be instituted under the due process of law. No such injunction can be. That is my case. That is my point, my lord. So therefore, first, my lord, we are all adidem that a civil court can never pass an order which will not directly or even indirectly restrain an authority from instituting proceedings. That is not possible. Now, my lord, the question of status quo. Suppose there is an order of status quo as regards possession. Then, my lord, what happens? Does not, again I say, by virtue. My lord, not, but with the greatest of respect, that status quo order cannot bar. Yes. Yes. So therefore, it has to be interpreted to mean that an order of the civil court will never be in violation of section 41 of the Specific Relief Act. At the most, what will happen? Proceedings will continue, because the proceedings under the special act will not result in disturbing the possession. I will have to get an order of eviction. Even if I get an order of eviction, his possession will not be disturbed. There again is a mechanism for execution of that order, maybe by the authority under the statute. So therefore, my lord, the order of status quo or status quo of possession to be read with the prohibition under section 41 of the Specific Relief Act can never imply that a proceedings which has its source or jurisdiction under a special act can never begin. At the most, order of eviction, if passed, again the due process will have to start for the purpose of eviction. So it cannot be said that civil court has passed an order of status quo, therefore the proceeding is in violation of the order of status quo. Damages can be governed by arbitration or arbitration. Yes, that is what the Supreme Court judgment, which my learned friend has cited, the Settleware is a corporation, that is specifically what says. Proceedings have not been said to be barred. The Supreme Court is saying the issue was of renewal of the lease, and the renewal of the lease issue can be decided in arbitration. But the Public Premises Act was concerning eviction only. So there is no case of conflict between the two acts. If it is a case of damages, that the arbitration can proceed, subject to the issue of determination of termination being decided by the appropriate authority. Arbitration cannot take place. But I will bow down to your lordship on your lordship's observation. If a suit is barred by the special statute, then the arbitration cannot take place of the same subject matter as the suit. But of course, if it is a claim for damages, which my learned friend is claiming, which is a cause of action which may flow from termination but distinct from termination, then he can pursue his remedy before the arbitrator under the arbitration clause, or in the case of a suit, he could have proceeded with the suit only for the purpose of his claim for damages. No, his possession is not disturbed. He has a right to say that I am not an unauthorized occupant. It is like, my lord, he has a right to file his defense. Today, my lord, kindly consider, if I had not gone to the Public Premises Act, I would have, if I had filed in an arbitration, I would have asked for recovery of possession. He would have filed a counterclaim saying, no, termination is bad, I am not, my possession is lawful. The same counterclaim he will file that I am not an unauthorized occupant because the termination is wrong. This is not a breach, therefore the termination is wrong. Therefore, I am not an unauthorized occupant. So there is no question of being remediless. It's just the act is a special act and has a special mechanism for adjudication before particular authority. Not that your right of defense is taken away, then the act will be ultra vires. This is based on the same central act.
There are several causes of action crossing command, and there are several fora which can decide on the plurality of causes of action, and there is one which can decide on.
No, but no, my lord, that is with regards to suit. But where there is a special act, that, my lord, it will be clear from that Supreme Court judgment.
May I just intervention? Let's suppose in the writ jurisdiction there are 9 groups. Now, your lordship is taking the land, group 1, suppose. Now, in group 1, there is another, suppose this case, recovery proceeding has been initiated on the Bengal Public Demand Recovery Act. Now, this comes under the group 9. Now, your lordship has no jurisdiction regarding the group 9 matters. If it is, if I can substantiate out of these 2, your lordship is having one jurisdiction, your lordship also can take the another jurisdiction also.
8A.
Exclusion, 8.
Special bar.
Special 8A. Yes, absolutely correct. 8A.
Bar, absolute bar.
Now, so far as express bar is for the purpose of suit. Now, where I am also exercising my right under the Act, Section 1996 Act, Section 9, also speaks about the protection of the property in question.
Yes.
Yes.
We come back next Thursday.
Yes.
No, date is fixed. Absolutely.
My lord, I would not have troubled your lordship now. My lord, the issue is that, my lord, in a matter, my lord, pertaining to urgency, my lord, with regard to a penalty imposed by the GST authorities, my lord, where the date is tomorrow, my lord, we had preferred a writ application. My lord, we had taken leave. As a leave matter, it appeared before Justice Krishna Rao today. Now, my lord, citing lack of determination, my lord, it was released. The matter would be placed before the appropriate bench. My lord, the order has also been approved. My lord, I would be beseeching your lordship, my lord, since it pertains to your lordship's bench, my lord, if this matter could be taken up tomorrow. Today also it appeared as item number 1, my lord, if it would be taken up tomorrow. Because, my lord, there are two issues over here. One is that, my lord, the penalty has been imposed as per section 129(1)(b) of the GST Act. That is when the owner does not come forward. We have admittedly come forward with the payment, yet they have not gone as per 129(1)(a), where the penalty would be about, my lord, in this case would be about 4.5 lakhs. They have brought the penalty, my lord, to 79 lakhs. They are asking us to deposit by tomorrow, my lord, because these are perishable goods. Where your lordship knows that the period can be reduced in perishable goods. So, my lord, otherwise they will dispose of my goods. My lord, this is appellate side, my lord. Appellate side matter, my lord. My lord, if your lordship can kindly, my lord, because we have already, this matter pertains to the circuit bench at Jalpaiguri. Now, my lord, the circuit bench is not in Sicily. Now, my lord, it will start from 15th of this month. Now, the problem is that, my lord, we had taken leave. The matter was taken up today. Thereafter that, because of lack of determination, my lord, the issue arose that it pertained to, my lord, your lordship's bench, which is why, my lord, it has been sent. But there is urgency, my lord, which is why. Otherwise, my lord, I would not have troubled your lordship. My lord, if it could be kept at the time tomorrow, my lord. Appellate side matter. I'm sorry, I'm the chief. There case status stuff. Yes, my lord. Yes, my lord. It's the case status also. Debrief.
Mentioning one original side matter for notice, your lordship, the urgency is that in spite of informing the department that I have preferred a writ petition challenging the show cause notice, your lordship, we have given the third intimation for hearing. And your lordship, apprehending that they may pass an order, your lordship, saying that third. Your lordship, because I am challenging the show cause as premature, your lordship. Your lordship, they will pass an order and then your lordship, my writ would become infirmable. Hearing is on 11th, your lordship, and the writ petition is appearing as item number 21 in today's list. Any day next week, your lordship.
11th.
Your lordship, because your lordship, I have paid for amendment of my bill of entry. So your lordship, if the amendment was allowed, then the writ petition would have, then whether the amendment is allowed or not, thereafter whether I am.
My lord, I'm being led by Mr. Day and I'm there also. My lord, not on Monday, my lord, Mr. Dev. I have some difficulty Tuesday, my lord, because the hearing is on 11th. So Tuesday, yes. Tuesday or Wednesday, if my lord hears preliminary test, nothing, my lord.
My lord, this is my exception, my lord. Just have to that.
My lord, we have filed a evidence and annexing the document by which the operation will take time. Any extension of time will be the so-called notice. That document is annexed there. I have a copy of it, my lord. Can take some mind evidence, my lord.
Exception to the na. No. Hello. My lord, my lord, kindly go through my extension. The officers should be punished by your lordships. Kindly come to my exception. My lord, paragraph 1A.
that the customs authorities have on affidavit filed, forged, manufactured, tampered, false, just and practicing fraud upon the honorable. Why? My lord, kindly come to the annexure, my lord, page 6 and 7 of their affidavit. Kindly 6 and 7. The officers should be dealt with by your lordship strictly. My lord, kindly see the logo first. Page 6, page 5. Page 5, my lord. See the. এটা জজ সাহেবকে দেখান তো, দিস ইজ অলসো অরিজিনাল লোগো। নিয়ে যাচ্ছি আমি, জজ সাহেব কোথায় নিয়ে যাচ্ছি, লোগো দেখুন মাই লর্ড কাইন্ডলি সি দি লোগো and see the logo of the forged document, page 7.
This is no seat.
Page 7, my lord. Yes, my lord. 6, 5 and 6. 6. Kindly see the logo. My lord, as if, but kindly see the logo, my lord. But that logo was tampered, manufactured. The document, my lord, kindly come to paragraph 2. My lord, kindly come to page paragraph 2 of my exception. Before going to deal with the affidavit, I swear on affidavit that the document at page 6 is manufactured. If a manufactured document is placed before the lordship, kindly see the. No, I am not a gentleman. But kindly see the document. Kindly see the document.
How do you say that the logo is tampered? What is the evidence that you have to show that the logo is tampered?
It should be.
That can say that the logo is tampered and I have to believe it. This is an affidavit affirmed by a competent authority before this court.
Well, plain, open eyes, one can see. And then kindly see the document. Document, my lord. Page 6, one can see. Of their affidavit, my lord. Well, according to me, my lord, kindly see the signature. The signature, I am admitting the signature is mine. But the date is given by the so-called officer who signed this document. Date. But it should be on affidavit, by submitting one thing, it should be sent to the forensic science laboratory. My lord, a officer, even an officer, my lord, on oath, my lord, try to befool the honorable court. Well, kindly see where is the receipt? Only signature. Receipt must be, my lord, only left side or right side or body of the. Kindly see. Well, my allegations is at the time of seizure, my lord, blank paper. That document is manufactured, my lord. Yes, well, 100%, my lord. My lord, this is manufactured document, my lord. Well, open eyes, one can see. Well, kindly see the logo, my lord. My lord, kindly see, my lord. Well, I have seen the difference, but you yourselves cannot see the difference, my lord. Then, my lord, kindly record all my submissions and pass it in order. All the submissions which I have, my lord, put in the exception, my lord, kindly record all my submissions and pass it in order.
Well, only I answer to this question, my learned friend, there is, my lord. If your lordship takes up their exception at page 4, what he has stated, my lord, leaving, my lord, paragraph 2, my lord.
And my lord, I have also and my lord, I have also given the specimen copy of the letter. A specimen copy I have given. Not nice words, my lord. If a person, an officer, my lord, on oath, my lord, if he places a document, false document before the honorable court will. Well,
My lord, admittedly, he admitted, now my learned friend admitted that the signature at page 6 of the my lord, departmental document, my lord, the signature bears the signature of the my lord respondent. There was nothing remained to be agitated in this.
there you, well, my affirmative is, my lord, my submission is that
Date was. Well, it will also kind.
and my question, my lord, that signature is procured on blank paper at the time of seizure, my lord.
Well, if you logically sees, my lord, the annexure 5, page 5, the reference number given in C number, etc., etc., that similarly it has been quoted then page 6 also, my lord. The logo might be only at the time of Xerox, my lord, maybe not.
Not that, my lord.
Yes.
But that is the format. No, that is, I am not of that. The format of the letter of communication. Well, then I have nothing to say, my lord. Kindly record my submissions and pass it in order.
So it is a case of attempt to smuggling. A clear case of attempt to smuggling. My learned friend now stressing on the point there is no reason in the order. That is the only issue now before your lordship, my lord. So, my lord, if your lordship kindly takes up the adjudicating authority, my lord, verbatim what my learned friend says is cut paste from the so-called notice. Well, facts are enumerating from the always from the plaint in a suit, in a read then writ petition, in a so-called from the so-called also. Therefore, the question of cut paste verbatim, I think, have no legs to stand upon. That has to be cast paste. Because does not know what is the fact. Factual aspects of my lord. Yes. They kindly come to my lord 224. My lord, kindly, my lord. My lord. Finding that I want to place, my lord. Page 224 kindly sees, my lord. My lord, 2.2. Lordship will 224. It will not tally to your lordship. 221. Just 7 bit of attack. My lord, this is referring from starting from 2.2. My lord, if your lordship kindly come to finding with respect to Vikas Bose. I have carefully gone through the records of the case as well as the written submissions dated such and such filed by Vikas Bose, and I find that Vikas Bose had a pivotal role in attempted smuggling of poppy seeds in guise of misdeclared transshipment consignment of seed Lafa. Vikas Bose tried to mislead the investigation by stating that he did not have any document in relation to the consignment other than original bill of lading and authorization. He further stated that the importer had told him that all other documents are being processed. However, inquiry with the shipping agent revealed that Vikas Bose was already in receipt of original bill of lading and other false documents having false details about the content of the imported container. Vikas Bose was actively pursuing the clearance of import container independently in absence of any directions from the importer. Then Mal kindly turn the page. Well, then I have now facts from their submission. So this is the conclusion. How do you think? Well, link, well, if I see the statement of Lafa and the Vikas Bose, if I tally both the statement, we will also find. Initially, he said, I have only one document, bill of lading. Subsequently, my lord, apart from that, kindly appreciate, my lord, he is working for the importer.
Page
and
190.
from his own pocket, he paid the amount, and he admitted that that amount has not been returned him. My lord, kindly see my page 225. How he has been personally interested, kindly appreciate, well. 225, kindly see, my lord. See, Vikas Bose, Roman 4. Vikas Bose had already proceeded towards getting the container released from the shipping agent using documents having false information and also paid the necessary charges from his own pocket. He further failed to disclose and refused to divulge details about the supposed supplier or any other parties involved with the impugned consignment. Well, that is from the statement. That is from the. My lord, kindly, my lord, page 198C, my lord, statement of Vikas. One 3.2, my lord. My lord, Roman 2. He got the job of clearance the imported impugned import consignment directly from Lafa. Lafa knows what goods are there, my lord, kindly appreciate. And he has a relation for the last 10 to 12 years with the Lafa. He doing the work for him. He knew Lafa 10 to 12 years as he had. One minute. my lord, first your lordship, my lord, page 1, next page, my lord, Roman 5. Roman 5, kindly see, my lord. He stated that apart from the original bill of lading, 119, my lord, 199, my lord, above, my lord, Roman 5. Kindly see, my lord, upon coming to Kolkata, my lord, it starts from 3.2. 3.2 statement of my lord Vikas. Three point two, my lord. No, no, no. Then my
Your
lord,
lordship, it is 195 in your lordship.
Arrest of Lafa Sharif, so
just above, my lord, just above. Just above arrest of Sri Lafa, my lord, kindly see. No, no, above that, my lord, above that. Upon coming to Kolkata, just prior to the day of examination, he was supposedly already informed by Lafa that the imported container contains poppy seeds. Therefore, my lord, he has knowledge regarding the goods which have been imported. Poppy seed, which is the prohibited goods. It is within his knowledge, my lord. Therefore, the regarding, my lord, abatement is clear from the statement of Lafa itself. And thereafter he said that I have only bill of lading. Subsequently, he produced all. No, yes, that is the statement of my lord Vikas. And Lafa informed him that poppy seeds are there. Then, my lord, kindly see Lafa, next point 4, kindly sees, my lord. He had admitted to have been known that the container contained goods other than what was declared in the documents. And again, he said, I amend the license, I shall do other things, documentary evidence, etc., etc. Well, above Roman 5, my lord, the statement of Vikas is very important. 2 lines, my lord, at the top, my lord.
Container is informed after that the important content poppy seeds.
That's why, my lord, because he knows everything. Because knows everything, he was informed by Lafa, and it is his own statement. Where is the detraction that no, the statement is bad? Even retraction, my lord, 108, my lord, in settled principles, my lord, it is not, my lord, 161 of the CFPC. And my lord, one judgment is lying, my lord, kindly sees, my lord. Our Division Chief Justice, Division, my lord, kindly sees, my lord.
Another question of law, it from appeals arising out of the tribunal.
My lord, kindly sees, my lord. The question of law frame. 2, my lord. Whether the learned tribunal should have considered an erred in law in not considering that the entire so-called notice, John Miranda
that the petitioner
and Rakesh Magu or the importer have never given any statement alleging, then no, 2, my lord. Serial number 2, kindly see, my lord. Roman 2. Whether the learned tribunal should have considered an erred in law in not considering that the petitioner, after obtaining authorization from the importer, such and such, in course of ordinary business, filed the bill of entry on the basis of the invoice, packing list, bill of lading, import, export, code number, etc., provided by the importer. The goods were examined by the customs officer and clearance was done and handed over to the importer. As a CHA, the petitioner was never a party, or it is not possible for the petitioner to be a party to undervaluation of the goods, as a petitioner is no way related with the goods. There is no evidence being adduced to the effect that the petitioner is in any way involved in such activities. So the question of adding or abating in the duty evasion in respect of bill of entry filed by the petitioner as a CHA does not or cannot arise. We have heard such and such. Then, my lord, paragraph 4, the appellant is a custom house agent, and by an adjudicating order, penalty such and such has been imposed on the appellant. Agreed by such order, the appellant preferred the appeal before the tribunal, which was dismissed and agreed by the same appellant before us. We have elaborately heard. Then, as could be seen from the order adjudication, the allegation against the appellant are very specific and has been noted in paragraph such order in original, which is the basis on which the so-called notice was issued. Therefore, liberty was granted to the appellant, then that is not important. Therefore, liberty was granted to the appellant to file the reply, and they were personally heard in the matter, and the order was only passed. The adjudicating authority in paragraph 7 has clearly brought out the modus adopted by the appellant, how the appellant was a party to the entire undervaluation exercise. This factual finding has been affirmed by the learned tribunal. We find no question of law, much less substance question arising from the concept of appeal. Ultimately, appeal was dismissed. There is a similar case here also, my lord. And my lord, without preferring appeal, they assailed this writ petition before lordship, saying that as a appeal, they are arguing, my lord. Had that been the case, my lord, here is a clear admission of the Vikas, my lord, that he is direct control, direct involvement in the smuggling. He knows the goods are poppy seeds. He was informed by his importer, who has the relation for the last 10-12 years. Therefore, my lord, abatement is clear from the statement of Vikas itself, my lord.
From prior to day of the examination,
and there is no detraction. This is statement, my lord, this kindly see, my lord, 3.2, the Vikas statement. Kindly, my lord, then kindly turn the page, my lord. My lord, Roman 3, kindly see, my lord, Roman 4, my lord. He mentioned that he received the original bill of lading. Page, my lord, 198. My page is 198, my lord, it will, does not tally.
195, your lordship. Your lordship,
3.2.
195.
3.2, my lord, statement of Vikas. He mentioned Roman formal. He mentioned that he received the original bill of lading and authorization letter from the importer. Upon learning about the alert issued against the import consignment, he called the importer Sri Lafa to Kolkata to be present during the examination of imported goods. Upon coming to Kolkata just prior to the day of examination, he was supposedly already informed by Lafa. That the import, it is his statement. It is. Lafa.
Suppose is already informed.
Your lordship, see, your lordship, I will again show. Your lordship, the petitioner, paragraph 2.2, your lordship, the chain of event will be clear. Page 192 in your lordship's brief. Your lordship, very quickly, your lordship, I will not.
Well, I've got a fixed matter at CPM at court number 6.
Your lordship, should we continue another day? Or your lordship, I can, on this point, I can just within, your lordship, only thing I wanted to say is that when they issued an alert, customs issued an alert, he came to know, he informed the importer to be present. And then the importer came to, that is what I am not saying, your lordship, what the paragraph which my learned friend plays. That is what he's saying. When your lordship would read the paragraph again, he received the alert, he informed the importer to be present. Goods will be examined by the customs in the presence of the importer.
Where is the information given to the customs authority that he came to know?
Your lordship, paragraph
why he is
your lordship, I will continue. Your lordship. Your lordship.
I would have an order, my lord, to be repeated.